Hi, everyone. Thank you for joining us today. I'm Marche, the webinar director here at Advice Chaser. Before we introduce our guests and get started, I do need to do a little bit of legal housekeeping. Advice Chaser, the host of this webinar, is not a registered investment advisor. We cannot and do not give financial advice. Today's presentation is for educational purposes only and cannot be considered advice for any person's individual situation. Advice Chaser regularly hosts informative webinars, such as this one, featuring a variety of knowledgeable professionals, many of whom are licensed advisors. Any opinions, ideas, jokes, or principles expressed by our presenters are their own, and however true, funny, or interesting, are not endorsed by Advice Chaser. Please do not act on the information you hear today without consulting a qualified financial professional. Well, we're thrilled to bring you this educational presentation. Attendees are muted, but we encourage you to ask questions using the chat box. Our presenter said she's welcome to answer questions during the webinar. So go ahead and put those questions in the chat. If we can't get to your question today, go ahead and leave your phone number as well. And we'll make sure someone reaches out to you after today's event. We want this experience to be as educational as possible, so please don't hesitate to reach out for clarification or expansion of the material. I'd love to introduce you to today's moderator. Let me go ahead and go to the next slide here. Michael Hart is the CEO of Hemispheres Investment Management, a global investment management firm he founded in 2014. That manages both equity and balanced account portfolios for individuals. He has over 34 years of capital market experience. From 2007 to 2013, he worked as a managing director at Tradewinds Global Investors, where he was a global equity and emerging market equity portfolio manager and a global securities analyst. Prior to Tradewinds, Michael founded and operated Hemisphere Asset Management from 2000 to 2007, and the firm managed global equity, fixed income, and balanced accounts for individuals and institutions. From 1989 to 2000, he helped manage the investment portfolios of the Farmers Insurance Group of companies as a senior portfolio manager. And during this institutional tenure at Farmers, Michael spent 8 years working as a portfolio manager of emerging market debt investments and 4 years as portfolio manager of international equities. He helped increase the value of the insurance international investments to over 1.1 billion from approximately 50 million. He's also received awards of merit for generating outstanding returns as a portfolio manager of foreign fixed income and equity investments. And Michael, why don't you go ahead and say hello so people can see your face?
Thank you, Marche, and good morning, and it's a pleasure to participate in this webinar.
Well, we're glad to have you, and I know that we're glad that you're here as a moderator to also add that component as well. I'd love to introduce our speaker. Stephanie O'Neill is an attorney with the law offices of Marcella A. Bell. Stephanie has a BA in economics from Dartmouth College and a master's in urban planning from UCLA. She graduated with her law degree from the UCLA School of Law, and she's been a member of the California Bar since 1995. As a practicing attorney for 26 years, she is specializing in the area of estate planning for 6 of those years. In addition, Stephanie has been an adjunct instructor for the past 15 years at several community colleges and UCLA Extension. And Stephanie, we're so thrilled to have you here, and I'm going to go ahead and turn the time over to you, and let's get going.
Thank you so much. It's really a pleasure to be here, and I appreciate the opportunity to speak at this webinar, and I do encourage any questions you have as we go along. We are going to talk about revocable living trusts, what they are, how to create them. Before we jump in there, though, I do want to talk a bit about estate planning and what that means, just by way of background, because a revocable living trust is part of an estate plan. Generally speaking, you don't want to just have the trust without having certain other documents and things in place. So first, I want to just demystify this word estate. When you think about an estate, what do you think of? Do you think of this kind of mansion, this kind of place where you imagine someone with lots and lots of money lives and probably has more mansions besides this one? And that's really a misconception, because what an estate really is whatever a person has, whatever our assets are, our money and property. So it's a misconception to think you have to be rich to have an estate. And whether our estate is in the 4 figures or the 10 figures or more, that's still an estate. It's money and property and assets that we, generally speaking, worked hard for. Most of us are not handed that. So we spend our time and effort developing those assets and increasing them. So it's a myth to think that we don't need to plan for our assets if we're not what we consider to be rich. So there really is no minimum dollar amount required for estate planning, and it is encouraged that everyone come up with a plan rather than thinking, oh, I'll do it when I have more money or when I buy a house or have children or something like that. So it's a good idea to plan for the future. And so I just want to briefly mention, besides the Revocable Living Trust, which we will get into, what other documents are part of an estate plan. So there's, oh, sure, first I should back up and say, well, what is estate planning before we move into the documents themselves? What we mean by estate planning in this field is creating documents to memorialize our decisions and our wishes, so that in the inevitable event of our death and the potential unfortunate event of incapacity, our family and friends know what we want and have it documented, and they don't inherit a situation that can be time confusing, or oftentimes contentious within the family, because families may disagree about who gets what and what an incapacitated person wanted. So that's why we create a plan. And that's why it's good to do that. And we can always update our plan and change our plan as our situation changes. But so let's look at the documents that generally are included in a estate plan. A trust, and as I mentioned, and as you know, today we're going to talk about revocable living trusts, and a will. You've probably heard of a will, even if you aren't familiar with trusts. And even if you have a trust, it's a good idea to have a will, and I will explain that today. An advanced healthcare directive, and you may know what this document is, but this is a document where we name an agent who will handle our healthcare decisions if we're incapacitated. So we're alive, but incapacitated. And I did want to share a quick little true story about 2 celebrities a couple years ago, young, relatively young, they were in their early 50s, Luke Perry and John Singleton. Both had strokes 2 years ago. Luke Perry must have had an advanced healthcare directive because his family took him off life support a few days after he had the stroke, when it became clear he wasn't going to recover or get better. John Singleton did not have an advanced healthcare directive. So about a week after he had a stroke and was incapacitated, his mother had to file in court, asking the court for the authority to make healthcare and financial decisions for him. The day after his mother filed that, John Singleton's daughter filed another petition contradicting her grandmother. So you have this playing out in court in a public way. John Singleton ended up passing away before the court resolved it. But that was an example of what happens when there is no healthcare directive in place. The doctors don't have the authority to take one party's word about what the person who's unconscious would want. So a really important document to have as part of our estate plan. The power of attorney for finances likewise comes into play when we're incapacitated but alive, and it gives someone who we name in the document the power to handle all our financial affairs while we're alive and incapacitated, and also important because we never know what's going to happen. The other documents that are part of our plan are beneficiary forms. And beneficiary forms you may find with your retirement plans. You may find them with your life insurance plans, where you name beneficiaries who are going to get the payout of life insurance or get the retirement account money when we pass away. You can also do those beneficiary forms for your savings account, checking accounts, investment accounts. They're usually called payable on death or transfer on death forms. So those are often part of an estate plan as well.
Stephanie? We have a question here. Are all these documents that have to be created by an attorney?
No, for sure you can. I mean, there's LegalZoom. I've seen people create trusts and wills with LegalZoom. I would caution that, because I've also seen situations where documents, a trust is created with LegalZoom, but nothing's put in it. And as we'll talk about today, if you have a trust, you got to put your stuff in it. So creating it and not putting your stuff in it does no good. But you can use LegalZoom. Advanced healthcare directive, you can usually create through your doctor's office or your healthcare provider. They will give you a form. Generally, you should get it notarized. You can get it witnessed. I would recommend having it notarized. Likewise, with a power of attorney for finances, you could probably go online and download one. Again, as long as it's notarized. I can't attest to the legality of it, but that's what people do to create these documents sometimes. Beneficiary forms, you definitely don't need an attorney. You just contact your retirement plan, your life insurance. If you have life insurance, make sure your beneficiary forms are up to date with who you want to name. If you want to do payable on death on your bank and investment accounts, you would contact those institutions and get the forms. So those are things to do without an attorney, absolutely.
And when should you consider creating or fulfilling all these, 5 highlights here for an estate plan?
Right. Honestly, I do recommend, even if someone's just 18, they do an advanced healthcare directive, because, you know, oftentimes our 18-year-olds go off to college, they leave town, and they're considered adults. And so I've heard of situations where parents, their children aren't incapacitated, but the parents can't get health information about them without their children's, permission. Whereas the child really would like the parent to know. And in that situation, with an advanced healthcare director for a young adult like that, you could create the form that says, my agent, my parents can know right away. I don't have to be unconscious. So the parents can be included in that. A trust, I recommend whenever someone either owns a house, has a child, or both. That would be a wise thing to do. If someone's just starting out in life, a new college graduate, besides the advanced healthcare directive, they might be able to just use beneficiary forms to name beneficiaries on their bank accounts, or sometimes still have joint accounts with their parents, so that if something terrible happens, the assets pass on. So as far as really, I would recommend sitting down with an attorney and making sure you have a comprehensive estate plan. I would say when someone's married, has children, buys a house. That would be my strong recommendation. So then let's talk about how assets pass at death before we jump into the revocable living trust. So there's several different ways this can happen. We talked about beneficiary designations, retirement accounts, life insurance, payable on death, transfer on death, joint tenancy or ownership. So we can own even a home as joint tenants. So couples often who are married own the house as joint tenants, or sometimes they put an adult child on the deed for the house. So these are all ways that assets can pass. When it comes to retirement accounts in particular, we don't transfer retirement accounts to a trust when we create one, because the IRS would consider that a taxable event. So we definitely need to name beneficiaries on the retirement accounts. If we create a trust, I recommend naming the trust as the last beneficiary. One of the issues to be aware of with this type of way of passing assets is, what if I name someone payable on death on some significant savings account where I have a lot of money? and there's a tragedy and we both die. Now there's no one named to get the assets, so we're going to have to go through probate. So the greater the asset is in value, the riskier it is to just do beneficiary designations. Again, when someone's just starting out in the workforce and they may have student loans or they don't have a lot of money in the bank, it's less risky to just use these type of forms. Assets that are not, beneficiaries are not designated are going to need to pass through probate. So the probate process is either going to be with a will. So if we have a will but no trust, our will is going to name beneficiaries who get our stuff. So in order for the bank to release the money or the house to change ownership, a probate court has to order it. So the will has to be filed in probate court. Without a will, if there is no will and there are assets that don't have named beneficiaries on forms, it still has to go through probate court, but now there's no will designating what the deceased person wanted. So state law kicks in. And generally speaking, the closest family members are going to get the assets, which might be fine with somebody if that's how they feel. Sometimes people don't want certain family members to get anything, but without a will stating that, they're going to have a right to get that money. One thing to know about probate in California, there's a court filing fee. Generally, it's about $450 to just file the probate. And attorney's fees are set by statute. So if someone does a probate with an attorney, the attorney's fees add up really quickly. Other states, probate's not as expensive. I had a client whose mother died in New York, and she didn't have anything, a trust or a will, but probate was only $5,000. And I say only because that's pretty cheap. California,
yeah, sorry.
Sorry, what's that?
Yeah, sorry, I didn't mean to interrupt there, but there's a question here. What exactly is probate?
Good, thank you for asking. So probate is a court process. There's a specific probate court where we're going to file for probate. And generally speaking, the probate court is responsible for gathering all the information on the deceased person's debts. You know, what are their outstanding debts and what are their assets? So first, debts have to be paid. So if there's money in the bank and a credit card bill or something else, the money's going to go to pay all those debts. Once the debts are paid off, whatever's left is going to be distributed either to the beneficiaries named in a will, or if there is no will, then whoever has a right to take by state law. So it's a court process. And in essence, the assets are frozen until the court works through the process, which
how does that take?
Roughly speaking, in Southern California, about a year. Can be a little less. With COVID, could be a little more, but generally about a year. And it's a public process. So it's open to public scrutiny. You hear stories about relatives appearing out of the woodwork to contest the will. So it's very public as opposed to a trust, which we'll get to, but great questions, thank you. So now let's finally turn to trust. So there are a number of different types of trust. Today, we're going to be talking about a revocable living trust. So we create a trust, and it allows the creator to control his or her or their, like a married couple could create a trust together, to control their assets during their lifetimes. And the document that creates the trust agreement, instructs how the assets should be distributed after death, who gets them, how much, when, at what ages, and that can happen without probate. So in contrast to someone with a will or with nothing, without a will, this can happen in private. The trust document and state law allow this to happen outside of the court process. So let's break down what we mean by a trust. A trust is like a fictitious entity that the law lets us create. So for example, I can create the Stephanie O'Neill Living Trust, and I can put my stuff in the trust. If I have a house, I can title it in the trust. So instead of the deed to my house saying Stephanie O'Neill, it's going to say Stephanie O'Neill, trustee of the Stephanie O'Neill Living Trust. My personal property is going to be transferred to my trust with a document. And then I have to go to my banks, my financial institutions, and get them to title my accounts in the trust. So again, instead of my savings account saying Stephanie O'Neill, it's going to say Stephanie O'Neill, trustee of the Stephanie O'Neill Living Trust. By putting my assets in the trust, now the trust gets to control how they're distributed at my death. So that's why it's really important to not just create the trust, but put our assets in it. Because whatever I don't need put in the trust is not going to be controlled by it. So let's talk about what we mean by revocable and living. Revocable means that we can change the trust anytime. We can terminate it. We can decide, you know what, I want to change my beneficiaries. I'm mad at so-and-so and I want to change things. So it's easy to change. We call it living because it's set up while we're alive. So it's a revocable living trust. Beneficiaries can be added or removed. We could add assets to the trust after we create it. We can take, if I decide to sell my house that was in the trust, I could sell it, just like I would be able to sell it if I owned it as Stephanie O'Neill. So there's a lot of flexibility here, which is the valuable thing about a revocable living trust. And just to be clear, again, I mentioned there are different kinds of trusts to create. Once we die, if I create a trust, the Stephanie O'Neill Living Trust, when I pass away, it becomes irrevocable because I don't want people to change it. I've laid out in my trust who gets my stuff and I don't want people to change it. So once I pass away, it becomes irrevocable. People who have super large estates, right now, the federal estate tax exemption, meaning that the federal government won't start taxing our assets that we pass to our heirs until we have close to $12 million. So most of us are not in that category, and California does not have an estate tax. But for people with super large estates, they get creative and do things with irrevocable trust while they're alive.
Okay, and we have a question here. How early should you put your assets in the trust?
When you create a trust, I recommend doing it right away, because generally attorneys who do revocable living trusts say that I'd already bought a house. It's in my name, Stephanie O'Neill, and I go create my trust. As part of the documentation that the attorney does, which by the way, all these documents need to be signed and notarized, of course, the attorney will do a new deed that transfers my house to the trust right away. And being here in California, generally speaking, our houses are worth a lot of money and are oftentimes a large portion of our assets. So that happens right away. And then depending on the attorney and the estate plan that someone signs up for, either the client needs to go out to their banks and institutions and retitle their accounts, or the attorney would do it for them. But I definitely recommend doing it right away. I mean, that's the point of creating the trust.
Thank you.
Sure. So a couple terms to know in terms of trusts and revocable living trusts. Trustor is the creator of the trust, sometimes also called a grantor or a settler. So I'm creating my trust, the Stephanie O'Neill Living Trust. I'm the trustor, I create it. I'm also the trustee because I'm the person who manages the assets in my trust. So initially it's the same as the trustor. I'm the trustor and trustee. I do happen to have a husband. We have a trust and we're both the trustors. And we're both co-trustees, so we manage our stuff. The successor trustee is a super important role. This is someone that we name in our document who's going to take over if we become incapacitated or when we die. So if you are familiar with a will, you've heard of the term executor. We name in our will an executor to handle or carry out our wishes in the will. That's the role of the successor trustee. So really important that we name someone in our trust who we absolutely trust as someone who's honest, because they're going to have control of our assets without court involvement, and also who will carry out our wishes. So super important. And generally it's recommended you name a successor trustee or co-trustees. Some people have adult children. They want to name their 2 adult children as co-successor trustees. They know they'll work well together and be honest. But we also want to name a backup because, again, we have to think worst case scenario, family disaster. So who's our backup successor trustee and even a third person? And those backups only come into play if our first choice is not able to serve, they're not around, they're incapacitated, or they just can't handle it because it is a big responsibility. So by naming enough backups in our trust, it helps ensure we won't go to court. Because what happens is if there isn't a successor trustee because they're all dead or refuse to do it, then either the beneficiaries have to agree on someone or someone's got to go to court. And we want to stay out of court with the trust, but the court's got to approve someone to be that successor trustee. Some other terms, beneficiaries are going to get the assets. So that's who we name, just like in a will, but we're naming them in the trust. And the trust agreement or trust document, that's the key. That's the contract that we create with the trust that names the terms of the trust. Who are our successor trustees? Who are the beneficiaries? If we transfer our house to the trust, we might describe in the trust what we want to happen to the house. We want to leave it to our children, and so on. Our restatement is where we update our trust agreement. So oftentimes people update their agreement 5 years later, or when they have a new child or grandchildren, or some other life event. So anytime you want to change your trust agreement, you can. You can have a first restatement, a second restatement, a third restatement. I've seen people restate after 2 years. I think the longest I saw somebody was like 22 years. So that's the beauty of the revocable living trust, is we can change our minds and change things with this restatement. And the name of the trust doesn't change. So it's still the Stephanie O'Neill Living Trust. My house is still stays in the trust. My bank accounts are in the trust. So I don't have to go back and change them. I'm just changing that trust document. So pretty straightforward. So how do we create a trust? Well, we choose a name. Pretty simple. I chose Stephanie O'Neill Living Trust to be my trust name. Then we have to decide the key terms of the trust agreement. Like I mentioned, successor trustees are really key. We've got to name someone we trust, we know is going to handle the affairs, and be honest and do it well and carry out our wishes. And again, I've seen people restate their trust because they named a successor trustee, their brother or friend or relative, who's now an alcoholic. And they feel like this is a bad idea. Until this person is where I feel comfortable with them being sober, I can't name them a successor trustee. So that's a reason to do a restatement.
Okay, there's a
We
question.
decide. Good.
Sorry, regarding
No,
the
go.
successor trustees. It's, do they normally receive any monetary compensation?
Excellent question. Excellent question. So serving as a successor trustee, the document always says any expenses the successor trustee incurs are covered by the trust asset. So if they need to hire an accountant, they want to consult with a lawyer, those are covered. The trust document or trust agreement also specifies whether the successor trustee is going to be paid or not. So you can compensate them. It would be taxable income if they're paid. Sometimes trustees, trustors, when they create it, they just leave a bequest to the successor trustee. They just say, John Smith is my successor trustee. And in the list of beneficiaries, they list John Smith getting $20,000 because that's not taxable. So it's really up to the creator of the trust. The other point to mention is there are professional fiduciaries who serve as successor trustees. And I've seen a number of situations where either someone's single and doesn't have any adult children, doesn't have anyone they feel comfortable naming as a successor trustee. So they name a professional fiduciary who will charge fees for their work, obviously. Or there are families, unfortunately, where adult children don't get along and the parents realize there's no way it's going to be a good idea to name any of them. So they name a successor professional fiduciary. So in that case, the professional will want to be paid. So whether you decide to pay a successor trustee depends on your individual situation. We also want to name our beneficiaries and the ages they receive assets. This is a great advantage of a trust. I can name my adult children as getting my stuff, but you know what? I don't want them to get, if I was lucky enough to have 6 or more figure estate, I don't want them getting that money when they're 18 or even 21. I want them to get it when they're 30 years old. I want them to find their passion in life, have to work for a living, and then they can get the money. Now, the great thing about that, the next bullet point, beneficiaries can receive money, what we abbreviate as HEMS, health, education, maintenance, and support. So before they reach 30 years old, they can go to the trustee and say, I need a car. Can I have some money out of the trust for a car? And the successor trustee can say, sure, here's your budget for a car. I always like to use this example because my younger son, who's in his 20s now, but he would want to buy a top of the line Mercedes or a Cadillac Escalade, tinted windows. So if he had that lump sum money, that's what he would buy at 22 years old. Whereas he can ask the successor trustee, and the successor trustee can say, sure, here's a reasonable budget for your new car. Find something for $35,000. And that way there's some control over the money. So the beneficiaries can always ask for money. And if they're minors, their guardians can ask for money. Many parents want their money to go for education. So they freely specify in the trust agreement that this money, we want it for college, grad school, even private lower level education, K to 12. So any reasonable request can be granted. It's just that there's some control over that money. I mean, I've seen people create trusts where their adult children don't get the money till they're 50, which is kind of late. More common ages are 30, 35. You can also say they get half the lump sum when they're 30 and the rest of it when they're 35. Lots and lots of flexibility in there. And then the really important point we've already mentioned, once we've created the document and everything is signed and notarized, we need to transfer our assets to the trust. And as I said, generally speaking, a lawyer who creates the trust should transfer any existing property, homes, investment property to the trust at the time of creation.
Stephanie, we have a couple more questions.
Good.
When would be a time you wouldn't want to use a trust? And the second is, I know the costs vary, but in general, what is the range someone can expect to pay to set up a trust?
Okay, so a trust can be overkill, as I said, for someone just starting out in life. They graduated from college or high school, they got a job, they're living with their parents, paying for an apartment, whatever the case may be, they don't have a lot of assets. They should still have an advanced healthcare directive and probably a power of attorney for finances, but they don't really need a trust yet. So that can be overkill. Once someone has any sort of significant assets, a trust can be worth the money because, again, you're avoiding probate. So you're doing your beneficiaries a favor by not making them go through probate and pay for it. And a key sort of measure that many attorneys, including myself, use, if you own a house and or have a child or children, you need a trust. In California, at least, you're going to benefit. As far as the cost, there is a wide range out there you will find. I would say for a single person, the cost ranges from maybe the low end, $1,600-1,700 on up. A couple is going to be more. I've heard fees as high as $5,000. And again, most attorneys are going to want to do a package of documents. They're going to want to make sure you have the advanced healthcare directive and the other documents we talked about. Otherwise, they're not really doing their jobs to just create the trust. And I will throw in here that even though we have a trust, we want a will. We call it a pour over will. And the reason being, I created my hypothetical Stephanie O'Neill Living Trust, put my house in it, and I go out, I inherit some money from my parents, and I go out and I buy an apartment building as an investment. And I'm so excited, I forget to title it in the trust. So I title it in Stephanie O'Neill alone. Well, now that asset is hanging outside the trust. If something happens to me, it has to go through probate. So I want that will as a backup. We hope we don't have to use it, but what that pour over will says is, hey, I have a trust. If there's any assets that I don't have in the trust, I want them to pass the same way my trust says. So that way, if my kids are getting everything, they're going to get the investment property too. It just has to go through probate. So anyway, the attorney package should include all those documents. I think on the high end, you're going to see $5,000-6,000. At the low end would be in the 2,000 or a little less range. All right, so what happens next? We've created our trust and all these other documents. We've had them signed and notarized. We want to give copies of the documents, especially the trust and the will, to our successor trustees so they know where they are. We want to give a copy of our advanced healthcare directive to our doctor's office, our power of attorney for finances to whoever we named in there. who, by the way, whoever we name as the successor trustee, we want to name as executor of our pour over will and as our agent in our power of attorney for finances. It just makes sense for the same person to hold all those roles. When it comes to our advanced healthcare directive, you can name anyone you want. That's unrelated to our finances and beneficiaries. So sometimes people don't want to name their adult children there. They figure, you know what, that's going to be too painful. So they want to name someone else, and that's fine. But once we've created our documents, given them to who we need to give them to, titled our assets in our trust, life goes on the same. You know, we handle our finances the same. I still got to pay my mortgage, pay my property taxes. I file my income tax returns every year, same way. Because it's a revocable living trust, the government and lenders consider us the owners of all that property because we have total control over the assets. We can cancel the trust. We can take the assets out. So we don't have to file any new tax returns. When the trustor dies and the trust becomes irrevocable, remember I told you that happens because we don't want anyone to change it. Now we have to, the new successor trustee has to get a taxpayer identification number from the IRS and file a tax return for the trust until the money is all distributed. So that's a change, and that's something where your successor trustee might need to talk to an accountant to do that. But for us, while we're living, things are the same. Life is great. And as we know, we can revise or amend the trust agreement. And so if we have another child, or we adopt a child, or get married, or have grandchildren, we may want to revisit our trust. Some attorneys, you know, every 3 to 5 years, write letters to their clients saying, hey, you want to check in and see if you need to make any changes. The other reason to make changes is if the law changes. As I said, right now, the federal law, the federal inheritance tax doesn't kick in until we're pretty wealthy, almost 12 million bucks each. If that changes and it gets greatly lowered and you have a trust, you may want to talk to your attorney and say, hey, should I do something different now to try to save money on taxes for my heirs? So that's another reason to revisit. Another important point, how does anyone know what we got? Yeah, we created this trust. Yeah, they know our house is in the trust. I gave them a copy of the trust document, but you know, we all have bills. We might have life insurance, retirement accounts, etc. We got to make lists. Imagine you were put in the role of a successor trustee or an agent for someone's finances while they're alive but incapacitated. You need a roadmap. So we need to create a list of all our bank accounts, investment accounts, insurance policies, debts, and bills. And I mean everything, right? Some of our accounts are paid automatically every month. Some we pay online. Very few we write checks for these days. But you want to give someone a roadmap for what to expect. They also need account numbers and login information, but that should be kept separately in a very secure place. Some people do these online programs for it. Others, it's in a locked file cabinet, but you want to let your person know because you trust them. This is where you're going to find my stuff. You know, when something happens to me, I laid it out in there. It's important to keep it up to date, which is something I'm pretty guilty of not doing because my brother is a successor trustee and he lives in a different state. But I need to update my list and say, oh yeah, I don't have Verizon anymore. I have AT&T, or yeah, I got rid of that credit card. Just so that, you know, maybe once a year, look at that list and update it is a good process to go through. So I have really enjoyed talking about this and I've loved your questions, and I'm wondering, does anybody else have questions?
Yeah, there's one in here, but how long does it take to create a trust?
Okay, so I can say it really depends on the client. So some firms are super busy and they will tell you they're backed up and they can't help you now. In essence, you got to wait. If a firm can take you, the time ranges honestly as fast as a week, turn around in a week, or it can take 6-8 months. And in my experience, the reason it takes 6-8 months is because people aren't making decisions. They can't decide who to be the successor trustee, who to be the backup. Another thing I should have mentioned too with the will, and the other reason we need a pour over will, even with a trust, if we have minor children, we need to name guardians. And in the pour over will, we're going to name our guardians for our minor children. And sometimes it takes people a while to decide who they trust to do that, or who they want to be the backup to the guardians. So in my experience, generally the process is dragged out because clients need time to decide. But average time, comfortable, I would say 2 or 3 weeks from the time someone meets with the attorney and gives them the information. And usually there's information to be gotten, but 2 to 3 weeks is perfectly reasonable.
And the other one is, what happens if you move out of state?
Really good question. You can still have your California trust and it can still be processed or administered under California law. If, for example, a client has a property in Utah or Texas, an attorney who's not licensed in those states, generally speaking, can't transfer that property to the trust. So they can still make that property part of the California trust, but they're going to have to find an attorney or maybe a real estate professional in that state who can do the transfer. So, I mean, moving to a new state, it could be time to revisit the trust and do a restatement, meet with an attorney in the new state to say, hey, I think it's worth the money to look at this trust and see under your state laws if I should make any changes. Does that state you move to have an estate tax? Like I said, California doesn't tax our heirs. When they inherit money, there's no estate tax on that money. Maybe another state has one. Maybe there's something you should do to try to minimize it. So I think moving to a new state is a good reason to revisit your estate plan.
I think that's about all we have time for questions. But if you do have a question while I'm reading the outro, you're welcome to go ahead and put that in the chat as well as your phone number, and we'll make sure to capture that and reach out to you if you didn't get your questions answered. I want to thank both Stephanie and Michael for being here. What an informative presentation. Thank you so much. Very interesting. I appreciate it a lot. And I know our attendees do as well. Thank you so much for our attendees for attending. Look for a link to a replay of this event, and you're welcome to share that replay with your friends and family. Here at Advice Chaser, we're all about helping you find a financial advisor who's a great fit for your life and your financial questions. Our matching service is free to you, and every one of our advisor partners is committed to offer a free initial consultation to anyone we introduce them to. So all you have to do is find out more by going to advicechaser.com and clicking on the link to find an advisor. So once again, from Advice Chaser, thank you so much. And we'll see you at another webinar soon. Thanks, guys. We'll talk to you later.